Dear participants here in Liechtenstein, as you have already heard, the Blockchain Act of Liechtenstein provides a comprehensive and technology-neutral approach to regulating the entire token economy so as to protect users and to ensure confidence in digital legal transactions. It describes the rights and obligations of service providers who perform activities on trusted technology systems. They are subject to registration and supervision by the Financial Market Authority, as we say here, FMA. Furthermore, some violations of rights and obligations of the law are even sanctioned by penalty or fine. The penal sanctions are regulated in Article 47. Here is the overview of my speech in the next 20 minutes. Paragraph 1 deals with genuine criminal law. That describes violations who are punished by the discrete court. In particular, an offense is committed by anyone who A, provides trusted technology services subject to registration contrary to Article 12. B, contrary to Article 24, uses a designation which suggests an activity as a trusted technology service provider. C, has obtained registration as a trusted technology service provider on the basis of false information or in any other unlawful manner. Or D, as a trusted technology service provider, systematically violates its legal obligations in a serious manner. Paragraph 2, on the other hand, does not define genuine criminal law, but only administrative criminal law, because the 10 violations described are not punished by a court, but only by the FMA, who may impose a fine of up to 100,000 Swiss francs. Paragraph 3 extends the competence of the FMA and regulates the imposition of a fine on legal persons. In this case, the violation shall be committed in the course of business activities of the legal person by persons who have acted either alone or as a member of the board of directors, executive board, management board, or supervisory board of the legal person, or by virtue, this is very interesting, by virtue of another management position within the legal person, by virtue of which they, A, are authorized to represent the legal person externally, B, exercise controlling powers in a managerial position, or C, otherwise exercise significant influence over the management of the legal entity. Paragraph 4 is also very, very interesting. Why? Because we read there a pure compliance provision. This provision extends the liability of a legal person for violations committed by its employees. The prerequisite for this is that the violations have been made possible or substantially facilitated by the fact that the persons just mentioned in paragraph 3 have failed to take the necessary and reasonable measures to prevent such acts. Paragraph 5 makes clear that the liability of the legal person for the offense and the criminal liability of the natural persons for the same offense are not mutually exclusive. And finally, paragraph 6 is about the negligent commission of an offense. And in that case, we have a penalty reduced by half. Good, okay, so far so good. As a professor of criminal law, I'm not here to describe or say only positive stories. I see my obligation as professor of criminal law to talk as well about the dark side of the moon. I will start with this, but then finally deliver a happy ending. I promise you. The potential applications of blockchain are unlimited. Nevertheless, the blockchain per se, that means simply through the actual possibility of its use, inevitably creates new possibilities for action and dangers, the management of which falls with the competence of criminal law. Without established regulation and oversight, the sector is often still referred to as the Wild West of the finance industry. This fact was also noted by G20 in Japan 3 years ago, and I quote an interesting sentence: "While crypto assets do not pose a threat to global financial stability, at this point, we remain vigilant to risks, including those related to consumer and investor protection, anti-money laundering, and countering the financing of terrorism," unquote. Thus, the following phenomenology of blockchain-based criminogenic behavior may result. Let's name just 4 examples. First of all, a fictitious blockchain comes into consideration as a classic fraud or serious fraud. This is the case, for example, when someone fakes the blockchain of an actually non-existent service and unlawfully enriches himself through corresponding asset dispositions. The crypto provider www.blockchain.com is also frequently misused for forgeries, in that offenders use email addresses and documents that appear to be authentic and supposedly originate from blockchain.com. In these forgeries, the victims are told that the amount with this provider is compromised and must be released by making a corresponding deposit. Another approach is that the recipients are supposed to confirm their credential, which, however, resembles a fraudulent phishing attempt. Furthermore, users may succeed in infiltrating child pornographic content, in particular into the blocks of a blockchain. However, the data entered into its blockchain can only be supplemented further and further, but cannot be changed afterwards. Anyone who downloads the affected blockchain could be liable to prosecution for possession of child pornography. In these cases, however, further questions arise. Who knows about that? When did one become aware as a user of the blockchain? When is there an obligation to deactivate the blockchain completely? In any case, this would be disproportionate for the Bitcoin blockchain. And finally, violations of copyright law are also very common when an art asset is digitalized without permission. However, the range of criminogenic behavior in relation to cryptocurrencies is much larger. According to the director of the board of the Austrian Financial Market Authority, approximately 80% of all crypto assets offered have a fraudulent background. While the financial loss resulting from fraud with cryptocurrencies amounts to an average of 40,000 euros, on one occasion, even a loss of 650,000 euros was realized. The latest crypto crime report from Chain Analysis also reports that cryptocurrency-based crime reached a new all-time high in 2021, with $14 billion flowing into illicit crypto addresses. As we can see from the future, many different types of criminogenic behavior come into consideration with respect to cryptocurrencies. And because Bitcoin is the first and the most famous cryptocurrency, we can talk about Bitcoin blockchain-based criminogenic behavior for the sake of simplicity. Its phenomenology can be exemplified, illustrated as follows. First, the criminal liability of illegal Bitcoin mining is conceivable by using other people's computers. In such a case, both data damage and misuse of computer programs or access data are possible committed crimes. A German court decision from July 2017 can vividly depict what this case constellation is all about. The offender set up a so-called botnet. That is an association of several computers on which programs automatically perform repetitive computing tasks in the background and which mostly go unnoticed by the user. The programs connect independently to a central command and control server, enabling the offender to remotely control the connected computers and use them for his own purposes. The offender achieves this by the computer users usually unconsciously opening a so-called Trojan horse and then installing it themselves. The botnet is intended to generate bitcoins, which requires a lot of computer power, and to spy on data. In this case of this court decision, a total of 327,379 users had downloaded the offender's Trojan, while 86 unencrypted bitcoins were seized. Another 1,730 bitcoins could only be temporarily secured because the access was password protected. The defendant did not reveal the password, or decryption was just not possible. Because Bitcoin users create their accounts anonymously, cases of extortion are also very common. A typical example of this is so-called ransomware attacks. What is that? These are harmful, malicious programs with the help of which the offender can prevent the computer owner's access to data, its use, or the entire computer system. In this case, private data on the foreign computer is encrypted, or access to it is prevented in order to demand a ransom in Bitcoin for decryption or release. On ransomware, the co-founder of Chain Analysis reported a few months ago that in year 2021, 74% of the revenue, and we talk about $400 million, of such criminal hackers flowed from extortions from companies to blockchain addresses that were most likely linked to Russia in some way. Another very large source of criminogenic behavior can be found in the darknet, an encrypted portion of the internet that is not indexed by search engines and requires specific configuration or authorization to access. This is full with marketplaces that offer entire assortments of illegal items for payments in bitcoins. In the best case, it is only about receiving stolen goods. In fact, other serious offenses are also committed, such as drug trafficking. A very recent case, is Hydra, the world's largest illegal darknet marketplace in terms of turnover, which was shut down by the German Federal Criminal Police Office. Hydra was a Russian language darknet platform, and its main focus was the trade in illegal drugs. In addition, data spit out worldwide, forged documents and digital services were offered for profit via this platform. In particular, the so-called Bitcoin bank mixer provided by the platform, as a service for concealing digital transactions, made crypto investigations immensely difficult for law enforcement agencies. However, the situation is also particularly dire with regard to distribution of hardcore child pornography. On the darknet, one of the largest abuse platforms under the name Welcome to Video financed itself through the use of payments in Bitcoin. A few years ago, it was finally shut down by international investigators. About 8 terabytes of data had been seized, including about 250,000 child pornography videos. Finally, the trade with bitcoins entails increased risks for the concealment of payment flows and thus for the facilitation of money laundering, organized crime, as well as terrorist financing. Among others, the Swiss Coordination Group for Combating Money Laundering and Terrorist Financing has also pointed out the serious situation in its current national risk assessment on money laundering and terrorist financing in connection with virtual currencies in Switzerland. According to this report, many financial intelligence units are also noticing an increase in the number of suspicious activity reports related to cryptocurrencies. A provisional agreement has even reached by the European Council and Parliament on June 29 this year, so that the European Union can take action against the misuse of cryptocurrencies for money laundering and terrorist financing. However, as promised, I would like to close my presentation with a happy end. The fact that blockchain, end with CSI, Prison Break, etc. Now we have a happy end. The fact that blockchain is being called upon to commit crimes and that cryptocurrencies, in particular, are being used for sometimes very, very serious criminal purposes is not too easy to say that blockchain technology per se is not to be advocated. On the contrary, it can be excellently used at the service of criminal law. And I believe in it very, very, very strongly. To begin with, blockchain can effectively protect digital evidence from tampering or loss in criminal proceedings. This is because both can happen due to human error or misuse of access through hacking, as well as hardware or software failures. Furthermore, blockchain can be very useful in the fight against crime attacks, thanks to its transparency. Looking at the current reports from FATF and Manival, money laundering and terrorist financing can be the main ones to think about. Through a blockchain, banks could build a network where all transactions are firmly recorded and KYC, as a Know Your Customer, documentation and suspicious activity reports are shared with each other in real time. Or, even more practical, Know Your Customer documentation could be incorporated into the private ledger and shared simultaneously with the other member banks, eliminating the need of each bank to perform duplicative Know Your Customer due diligence on the same customer. In terms of corruption, the World Economic Forum has already initiated a study on the benefits of blockchain. In the pharmaceutical industry, blockchain can also be a tool to prevent drug counterfeiting. Rather, the entire history of the medicine could now be traced. Finally, it would be a profitable idea for any state to auction off seized cryptocurrencies. As I say, everyone flirts with criminal law on a daily basis. With this in mind, please pay attention. And thank you very much for your attention.